This is a probation violation hearing in the matter of People versus Eva Bernice Holman. That's you. And you're here with your lawyer, Mr. Peter A. Taylor. Is that correct?
Correct.
All right. You were put on probation on charge of impaired driving last March with our probation agent, Daniel Frazine. Daniel will be up here in a minute. And he spent a lot of time on this probation, and frankly, so did you. But I thought TJ was going to be here.
I think this is just the arraignment on the violation.
It is, but I didn't know whether he wanted any input on this or not. Would you see if TJ's out there? I told him we were going to start this at 9:30, and we're actually a little early. And normally the prosecutor doesn't show up at the probation violation arraignment, but he was here and he wanted to participate, or at least be aware of it. Daniel, what do you have for a camera down there? Just one of these on top of your...
Yeah.
I think it wouldn't interface with these Jazz cameras.
Can you choose that? You could just choose that one, right?
Well,
or select it?
Probably, but I...
TJ Reed, right?
Yes.
Somewhere in the settings anyways.
Like I said, the time to practice isn't 1 minute before the show time, so that was on me.
Well, I saw that system. I'm like, what is this? Because normally we don't use that, and it downloaded it as it was clicking me on, and boom, it just popped up. It took about 3 minutes.
I hear TJ approaching. Yeah, he's just next door.
Again, he probably may not have much to say, but he said he was here and he would appear for this. We started a little early, Mr. Reed. And
no problem.
I didn't know. Normally, the prosecutor doesn't appear at the PV arraignment.
But I heard Mr. Taylor was going to be here, so
he thought he better get in on this. All right, let's call it again. People versus Eva Bernice Holman, 222569OD. Ms. Holman was placed on a probation last March on a charge of impaired driving with Daniel Frazine and has spent a lot of time and effort on this. Daniel filed a probation violation alleging that you failed to abstain from the use of drugs or alcohol or submit to a test upon demand of a probation officer or police officer or judge. The matter is set for arraignment today. So the arraignment is, I just tell you what the allegation is. Now you've taken the extra step of having Mr. Taylor with you, and that's fine with us. You would have a right to have a hearing regarding the probation violation. When you're on probation, you no longer have a right to be proven guilty beyond a reasonable doubt of the violation. The standard is lower, it's a preponderance, and you don't have a right to have a jury trial. You do have a right to have an attorney, and if you'd asked me, I would have appointed an attorney for you, but you've retained Mr. Taylor, and he's following this case all the way through, and that's fine with us. So Daniel gave a status report, which you have a copy of, Mr. Taylor?
I have the petition with the probation violation. I don't know if I have a copy of the status report.
All right. Well, I guess Daniel, why don't you let him see your copy of that? It details how things started to go. And it started out okay, and there were some struggles. There were some issues regarding the community service and some other things. On October 18th, she tested positive for marijuana. And then on October 31st, she was positive for alcohol and marijuana. And then she was diluted. On November 3rd, defendant denied drinking, denied being diluted, said she wasn't trying to dilute her results, and they talked about that. Daniel advised her if you just admitted it, we would just increase the AA attendance or do some community service or some other sanction. Although this is not correct, defendant stated something about an attorney, and he said you can do what you want. However, a PV has to be filed first. Attorneys are not allowed a probation violation arraignment. That's not correct. They're allowed. They're just not appointed until a probation violation arraignment. And then he goes on to say in the last paragraph, defendant has been polite with this officer, and although she has some hiccups in a few spots, she has done what she has been asked to do, with the exception of refraining from alcohol. Whether this officer agrees with the fact that the marijuana card have exceptions, that doesn't matter. It is what our legislators decide. The defendant was able to use marijuana, which she stated would help her sleep, anxiety, and not drink. It did not, and she consumed alcohol while she was on a term of probation, which this officer believes points to a bigger issue with alcohol than the defendant is willing to admit to. Without the defendant being willing to admit to the use of alcohol, there is nothing else to be gained from a continued term of probation. Defendant has completed all the other obligations, so this officer is recommending either an unsuccessful discharge or 1 or 2 days of jail if the defendant is found guilty of the probation violation, and a successful discharge, whichever the court decides is most appropriate. So, Ms. Holman, Mr. Taylor certainly knows this, you have a right to either admit to this violation or deny it. If you admit to the violation, then I'll decide what the sanction is. Either way, Daniel would like to terminate this probation and get off your back. If you plead not guilty to the violation, we'll set a hearing. Mr. Taylor can be here to represent you, and they'll have to prove that you either consumed alcohol or failed the test. Do you understand? Mr. Taylor, have you had a chance to discuss this with your client?
No.
Okay.
I mean, this is the first I've been made aware of this, Your Honor. However, Mr. Prezone's recommendation of unsuccessful discharge with discontinuing probation and no jail was what I was going to suggest as a resolution, due to the fact she's completed the Prime for Life class. She's completed 24 hours of community service. She's completed 24 AA meetings. As the court noted, she was placed on probation on March 13th for 1 year. Her 6 months for eligibility for early discharge would have run on September 13th, which was prior to the violations alleged in this point, right? So she was eligible. She was eligible for early discharge. She was continued on probation past that point. She's completed everything that probation would want her to do. I think she would be happy being released from probation, as long as the court wasn't going to order any other jail time.
Daniel, what's your thought?
That's fine with me.
Ms. Holman, ultimately this will be on you. And Daniel, I don't think meant to tell you couldn't have a lawyer at your arraignment, but generally we don't appoint one until we have the arraignment, and then you either admit or deny But you've done a pretty good job, and people who have substance abuse issues aren't evil. They struggle. And if it was easy, everybody would just quit. So you've been mostly alcohol-free since last March. We have reservations about marijuana use for people who are on probation on a substance abuse charge. In fact, all over the state is a big subject of debate. Michigan first passed the medical marijuana law that allowed people who were over 21 to use marijuana for legitimate medical purposes, and you have a medical marijuana card. Then Michigan voters overwhelmingly passed recreational marijuana. And as you know, anybody that's over 21 can smoke marijuana if they wish to. Our probations, in fact, like most probations around the state for drinking, driving, or drug charges prohibit marijuana use, except for medical marijuana purposes. In fact, there's a case, and Daniel alludes to it here. It wasn't what the legislation said, that the legislation enabled medical marijuana, and the case said people can use medical marijuana even if they're on probation, if it's legitimate. So that debate will continue to go on, but there's no point in having any additional probation. All fines and costs are paid.
Yeah, so we went in December, so it's $40, but.
All right. Do you admit that you used some alcohol during this term?
No, I was sick.
Well, let me ask this. Do you admit that your test was diluted?
Do you admit that you used some NyQuil?
I did because I was sick for 2 weeks.
And that NyQuil contains some alcohol? I mean,
that offends my sensibility at this
Yes,
point.
well, that is the
You're on probation. You're told not to do something. She's given the opportunity not to get jail and just to be done. And she's in denial to the point she's going to try to allude that she used NyQuil.
Which is why Daniel wants to revoke the probation.
Well, then I would say put some jail time component to it. If we just get to do whatever we want to the court and not listen to the court rules and come in and say, well, I'm not going to admit to doing wrong. I mean, come on. Look at the test results.
The NyQuil is something that would still make someone test positive.
That's
not at that level.
Not at that level. Come on.
And I've had a thorough discussion about the NyQuil. I cover that quite clearly.
Right, but generally you tell people not to use NyQuil, right?
Well,
I mean,
Your Honor, at this point,
can...
just set it for the hearing. I mean, this is ridiculous.
All right.
Just hold on a second.
All right.
Okay. I think she's ready to proceed, Your Honor.
Say that again.
She's ready to proceed with entering the plea at this point.
All right. You're right. What Daniel's concerned about is the defendant's lack of candor. It insults all of our intelligence to think that she got to that level of alcohol a day or two later. If she drank NyQuil like 2 minutes before she went in to take the test, it might have registered. But you're talking about 1 ounce of NyQuil, which is like 12%. I'm not even sure it has alcohol in it, but at any rate, this is not from NyQuil unless you drank 4 bottles of it. So all you have to do is admit, and that's where we're at Stonewall. Daniel's like, there's no sense of putting her on probation unless she'll tell me the truth. And she's in denial, and you're paying a lot of money to stay in denial. And as Mr. Reed said, just tell us the truth and we'll call it good. We've taken it as far as we can. And the one you're ultimately hurting is yourself. So the test was on October 31st, positive for alcohol. sometime around Halloween, did you drink some alcohol?
I'm sorry, Your Honor.
Did you drink some alcohol?
I guess. Yes, I did, I guess. Yes.
What was it?
Butterscotch.
All right. That wasn't so hard. The concern we have is this, I think, is your first offense. And the test was in the 1314 range. But you probably have inherited the alcohol gene. And Daniel's concern is we got you this far. We don't want you to slide back to the bottom of the hill. So the first person you have to acknowledge it to is yourself. But I'll note that you admitted the violation. I'm not sure how much of it you drank, but it was not NyQuil, which is really why we're here. If you've even acknowledged to Daniel that you had drank, he probably would have done some community service. We would have finished the probation and been done with it. But I think he feels he's taken it as far as he can. All right, Mr. Reed stated the position of the court. There was an agreement. So, all right, I'm not sure if you feel like you just told me what I wanted to hear, but I do believe you drank some alcohol on the 30th or 31st of October. All right, your probation is revoked. As Mr. Taylor said, you were on probation. 1 year probation can be completed at the end of 6 months. It was extended a little bit, as Daniel indicated, because there were some hiccups. There's no sense to continue the probation. You did some service for somebody that didn't qualify as community service. Then you actually did the community service. You did Prime for Life. You took a lot of tests. Now it's on you. We've taken you as far as you can go. You're either going to fall back in the pit or continue to get on with your life. All right, you're free to go.
And was the court, I believe there was $40 extra of.
No, I'm waiving all
this.
Okay.
We're only 3 days.
Yeah, I
Yeah.
just
December.
didn't know what, you know.
No. Besides,
Thank you, Judge.
Merry Christmas, TJ.
hey, thanks, you as well. See ya.
Yeah,
All right,
everything.
TJ, now you can
Yeah.
actually
Yeah.
get back to
Yeah.
work.
Yeah.